our program. We're going to have brief presentations. The idea is not to have speeches. We're going to have dialogue back and forth among the panel members. Each panel is going to have sufficient opportunity for audience participation to ask questions, and particularly on the morning panels, if you know of some internship program, for example, in the first panel, that's different in significant ways than the panels that presents it, we'd like to have that information out on the record so we have that before us. And the same is true if there are other reasons why employers do or do not have unpaid interns. We want that on the record, and the same about students. And there'll be opportunities to raise questions with the panel members. This afternoon on the law panel, we're privileged to have a representative of the Department of Labor who is going to be here and tell us what the Labor Department's position is on internships. I have a feeling that presentation is going to be fairly brief because, as you will see, they don't have very many of the answers, and it's a little unfair, but we finally persuaded somebody to come anyway and take our slings and arrows as we go through that. And then I'm going to pose a series of questions to the panelists, and we're going to try to explore some of the legal issues. And finally, Lance Liebman is going to come back for a reprise, and he's going to do similar things on the policy side at the end, and then I'll also have a few words at the end of the program. One final word before about the we will not have formal introductions between panels. At the end of the panel, we'll just come on off, and unless we have a break in the schedule, people will just come on up here. I will not introduce the moderators. You should all have a copy of the program and a separate list of the speakers. We won't have any formal introductions, except the one I'm about to give now for my old friend Lance Liebman, whom I have known for longer than either of us cares to admit. Back in the days that we were in law school together, Lance was a professor at Harvard Law School for many years, became the dean at Columbia Law School, served with great distinction there, and has remained there as a professor where he teaches both property law and employment law, including the Fair Labor Standards Act. He is also, in his spare time, and I don't know where he finds the spare time, he's the director of the American Law Institute, the most prestigious legal body in the country that does wonderful studies, including the world. Oh, yeah, the world. Oh. Well, since I only speak English, and I don't really, I wouldn't want to overstate the matter. He is the director and the major domo of all the projects, including most recently the project on employment law, to which I went when I tried to figure out what the status of volunteers are under the Fair Labor Standards Act, and found some useful material there, but unfortunately not any clear answers. So it is with great pleasure I introduce Lance Liebman.
Remember that Lyndon Johnson response to being introduced when and Johnson then said, "Oh, that was a very nice introduction. My father would have loved it, and my mother would have believed it." Okay, so that applies here a little bit. I would say Alan and I do not go back 50 years, but almost. And because of that experience, I feel absolutely confident when I say that don't believe him when he said he's going to come back in the afternoon with a few words. Okay, it won't be a few words. I'd like to start by going through three small stories that are from three different generations. Okay, and each focused on an individual. Okay. So the first one is Frances Perkins. Frances Perkins, who had a degree from Columbia where I teach, not from the law school, but she was a Columbia graduate. She was the first female cabinet member in the United States government ever. And that was in the 30s. She had worked with Roosevelt in Albany when he was governor of New York. He knew her well. And she was probably the most important Secretary of Labor in the history of the country so far, and was Secretary of Labor throughout Roosevelt's 13, 14-year presidency. And she was a crucial figure in everything the New Deal did. I'll just give you one story. There are a lot of very interesting stories about her, and stories that naturally are affected by the fact that she was the first female, and that was at that point a little different, thank goodness, than it is now, and whatever. But when the issue was whether the Social Security Act would be held constitutional, because the Supreme Court was striking down various New Deal laws, and the change in the court's membership hadn't happened yet, and there was lots of reason to worry about whether the enactment of Social Security in 1935 would survive constitutional review. Did the Congress have the power to do this? Exactly the same as the question we have today about the Obama health law and what we might get in judicial decisions about its constitutionality, but that was the issue then. And in those days, probably only a few miles from here, Justice Brandeis hosted people, New Deal figures, for tea every Monday afternoon. And I'm old enough that I knew them as professors who had been law clerks for Brandeis, and one of their tasks as his law clerk was to pour the tea, you see, at this like 4 o'clock or 5 p.m. tea that Mr. and Mrs. Brandeis had in their apartment up on Connecticut Avenue, and various people would come. So Frances Perkins is there, and Justice Stone is there, Harlan Fiske Stone, once dean of the Columbia Law School, and Perkins asks him whether there's a way to write a Social Security law that would survive review. And as presented in some book where I read it, I can't remember, but I know it was, remember what it said, that Stone sort of took Perkins over near the window. There were some curtains, and sort of they hid behind there, and he told her how to write it. That he said these words, at least they were printed this way: "The taxing power of the federal government, comma, my dear, the taxing power is all you want and need." Now the best words there are "my dear," of course, and so they wrote Social Security as two separate laws. One, the Social Security tax that everyone in this room has paid, and a separate law which said we'll give some benefits to people when there's, those days, 65 and computed on a formula like this and that, pretending these were two separate laws, and that the first one could survive as a tax, and the second one could survive under the commerce power. And then by the time Social Security got to constitutional review, the court had changed and things were going through, so this did not become a huge matter, and the two different laws were actually upheld in the same statute. Perkins then is in the midst of the National Recovery Act, which was struck down and was a very detailed attempt to manage the economy, almost, you could say, a socialist intervention, as was happening in various countries of Europe in the midst of the 1930s depression. After all, again, you know, we have not had a downturn from then till now as significant as the one we're now experiencing. So all this talk about the 1930s is not really irrelevant to us right now. So the National Recovery Act is struck down, and Perkins then comes up with the notion of what we now know as the Fair Labor Standards Act. And her thought was certain rules could be imposed from Washington nationally that would give certain protections to workers. And I'm reading now from a former student of mine, Adam Cohen, who has a recent book. He was the New York Times editorial writer about law and judicial appointments and stuff until recently, when he stopped in that job. Adam published a book about the New Deal last year called Nothing to Fear, a very good book. The version that passed Congress of the Fair Labor Standards Act, our subject for today's sessions, the version that passed Congress, version that passed authorized Congress rather than the Labor Secretary to set the minimum wage, which began at 25 cents an hour, rising to 40 cents in 2 years, and maximum hours, which were set at 44 hours a week, declining over time from the original statute, declining over time to 40 hours. So the 40-hour number goes all the way back to that law. It also barred goods made by children under 16 from interstate commerce. The act gave raises right away to hundreds of thousands of workers and promised eventual relief to millions of workers who earned less than 40 cents an hour. So that's enacted in 1938, and of course, they don't bother getting very detailed about who is an employee. There were a number of exceptions, including agriculture workers in the original act. That one has remained, and it's an extraordinary thing that there's never been an adequate political movement to give certain of these protections to agricultural workers who do work that, you know, all of us depend on every 3 meals a day. And many other exceptions and whatever. But that's the late 1930s. 1938, this is enacted. It's the early 50s when I get my first job, and I know now, counting back, that I was 13 and worked in a drugstore in the summer after freshman year of high school. And I think I made $1 an hour, which the minimum wage had gotten up to by then. But I've wondered, the more I think about it, and I teach this stuff, but I've never explored it, whether at 13 I was somehow, that the child labor provisions raised a question. The only thing I remember is I worked in a drugstore behind the counter in the summer. And we had very little money, and I know I had to work, knew I had to work every whenever. And this was in a small town in Kentucky. And what I remember is being embarrassed when men and women would come in and purchase certain products that to a 13-year-old, you know, were a little bit whatever. But then a couple of years later, maybe 5 years later or something, I worked in a factory in the summer, and I remember this very well, that say in June when school was out and I started, it was $1 an hour. But then after like 6 weeks or 4 weeks or something, it went up. This was not because of the law. The law was $1 an hour, but it went up to $1.05. And I remember that I could tell the difference, you know, that of course a Coke was a nickel in the machine, and, you know, nickels were not trivial. But anyway, that's where we got the statute. Francis Perkins, Secretary of Labor, Roosevelt, the New Deal, et cetera. The second thing I want to say of the 3 little stories I want to give you is it's now, I know the year, 2001, early in 2001, or maybe late 2000, and our daughter-in-law is a resident, you know, like an intern, finished medical school, has 3 years in a residency to become a physician, and then she gets pregnant. And, you know, think today, nearly 60% of medical students are female. Most of them are in their 20s or whatever, so one of them getting pregnant is not exactly a statistical improbability. And she says that they refused her any kind of leave. I teach employment law. And I said, Eve, the Family and Medical Leave Act was passed. It was the first act signed by President Clinton, so we know exactly when that was, early 93. This is 8 years later. She's working at a major hospital, and that has, I'm sure, 50 lawyers, you know, on the staff and whatever, and they're telling her she can't take the 8 weeks, 10 weeks, whatever it is, of unpaid leave that's in this federal statute passed 8 years before. And I tell her, give her the name of the law and the whole thing, and she goes back and forth. And what do they say? They say, you're not an employee, you're a student. And they really did. And she would leave in this internship, say this morning, you know, at 6 a.m. and come back tomorrow night, 36 hours later, after day, all night, and next day work, and she was being paid something like $40,000 a year. And they say, you're not an employee? Come on. So it took a while, but eventually they folded on this. But that, I'd give you that just as a way to think that there are all sorts of relationships. And this is Alan's point about looking at the attempt of the American Law Institute to write a restatement of employment law. It is extremely hard. This is in the first chapter of our work. It's in the first chapter of my casebook, What is an Employee? Defining an employee is not easy, and for sure, it was not going to be the same under every labor regulation. In other words, different labor is regulated in all sorts of different ways. We have a friend who's a prominent lawyer, head of a big firm, and lawyer in Paris. And maybe 5 years ago, 7 years ago, something like that, he was in New York, and we were getting together. And at that point, some of you will remember this, France had passed the law restricting work to 35 hours a week. This 40-hour thing has a sort of magic, and it's unchangeable in the United States, but it's not obvious that in 2010 it shouldn't be some other number, but maybe bigger. And anyway, the definition of work when you're walking around with a handheld device that can summon you at any time, one New York law firm tells their associates that you have to check your BlackBerry every 30 minutes unless you're asleep. And that's, whether you're working or quote working or not. So anyway, the French had just passed this very strict law about 35 hours a week. I mean, the Fair Labor Standards Act only says time and a half after 40 hours. It doesn't say they can't make you work more than 40 hours. But the French law bans work more than 35 hours in an attempt to create jobs by restricting what the workers can do. Maybe the employer is going to have to hire 3 more people or something like that. And so I said to my friend, this prominent Paris lawyer, so do your associates, the young lawyers, go home at 5 o'clock or some p.m.? I say 5, you immediately think of a.m., but they go home at 5 p.m. He looked at me like I was crazy. And I said, but we've been reading about this law, and it's getting a lot of attention and all this. And he said, no, it doesn't apply to the people who work for me. And if he didn't use those words, but and I said, well, what do you mean? I mean, I read in the New York Times, and he said, because these lawyers are independent contractors. Okay, they're not employees. Well, those are words, but they don't exactly answer the question. The third story I want to go into for just a couple of paragraphs. So we've talked about Frances Perkins, and we've talked about my sweet daughter-in-law and the resulting sweet granddaughter, our first grandchild. It was the result of that story, which I told you. But I want to then give a third thing, which is one judicial decision. I mean, I read a bunch of the cases, the legal decisions, which are not very helpful in terms of telling us about the application of the Fair Labor Standards Act to unpaid interns. There is one United States Supreme Court case, really, called Walling, W-A-L-L-I-N-G, 1947, but the case I want to talk about is a somewhat more recent one, and one of the reasons, not the only one, it's the most interesting I came upon in the ones I looked at. But it is true that it was decided by the United States District Court for the Southern District of New York, in other words, the trial federal court for Manhattan, and by a then obscure judge you would not at that point have heard of, called Sonia Sotomayor. So that's an excuse for talking about now Justice Sotomayor's decision. But this deals with an organization, and New York City has a bunch of organizations that are not public and not private exactly, and that are in different neighborhoods. And so we're talking now. The defendant in this case is called the Grand Central Partnership. So that's everybody who owns big office buildings in the Grand Central terminal area, the Grand Central train station area in Midtown. And now, is this the government? You are required to pay a little bit more on your real estate tax that goes to these so-called partnerships. They're nonprofit. I mean, they don't have shareholders who are going to make a profit, but they're not exactly charities. And the goal is to clean up the city. And by getting money that the real estate owner has to pay and that's handed to the city as part of the real estate tax, but then given to these so-called private nonprofit organizations, you then get an organization that's got some money and it hires people to pick up after us when we walk down the street and drop a Coke can and whatever, and clean up things and all of that, but also especially to grab homeless people and people sleeping against the building and stuff like that and move them somewhere. And, this produces a certain version of law and order. Okay. And note the advantage of a private organization. First of all, if you hired city workers to do the conventional work here, you'd have to pay them more. They've got a union, they've got a pension, they've got all this stuff. Here you hire people very cheap. And second, if you use city people to grab the homeless and others and inebriated people, all that, you get into constitutional questions about search and seizure. The police are limited in what they can do. So here's how you deal to some extent with urban conditions. Okay. And so what they were doing here was using unemployed, homeless people, telling them this was work and getting them to do stuff and essentially not paying them. And maybe that leads over time to their being able to get a job and do something. I mean, maybe this is training, whatever. It's certainly not coerced. They were paid some money, given some food, stuff like that, but not paid at the rate of the minimum wage, which today is $7 plus an hour. And so that's the question of it's not an internship, but it's employment being supplied or regulated. There's no serious attempt at education or at really moving these people along. That made a large difference to Judge Sotomayor. But what is it? It's work and it's do good and it's whatever. And that holding is that these arrangements violated the Fair Labor Standards Act, and that the minimum wage and hours and child labor all applied. But I'm not generalizing to the point that is what would happen in every similar case. So the law here has developed to a very limited extent. I mean, Alan's story was perfect. You talk to some law firms, they're interested, it's good for the students, it's fine, and then you start thinking, but wait a minute, do they have to be treated as employees under the law? Where is the line that separates? And at this moment, when so many young people, you've seen the figures and some of the stuff handed out for the meeting, that by some measures, 50% of all college graduates have done some unpaid internship, somewhere along the way before they got their college degree. And do we need more law for this? Do we have to find a way to get specific and supply some rules? So that's the purpose of today's meeting. And the only other thing I'd emphasize, I sort of said this already, but is that it's a part of a larger bunch of questions about the range of employment law and what the boundaries are between employee and something else. And looking into stuff for this, I read some articles, didn't read all of, but looked at some articles about prison labor, which raised certain questions. There's an interesting decision about a female volunteer at the New York City Bar Association. This occurred actually at a time when my wife was on the board of this association. She should be embarrassed, although it wasn't her fault. But this volunteer, a woman, lawyer who's doing stuff at the Bar Association like you do for nonprofits, allegedly sexually harassed, sues the guy who was like head of this thing. And the court decision is, no, you're a volunteer. You're not an employee. And so the protections under Title VII for sexual harassment don't apply. Well, that may be right, but maybe some other law then is needed, and quite possibly we really have to think about some kind of legal intervention, either from the Department of Labor or actually from Congress, or maybe at state levels to some degree, about these internship questions, because we want the internships. They're educationally good, but we got to be careful that we don't go away from at least some of the legal protections for the employment relationship that have evolved since the 1930s. Actually have not evolved that much. I mean, the law is not much more advanced than the one that Frances Perkins helped us get. And in any case, I think this is potentially a very important meeting all day, and I'll be back when we have all the answers. That I think it's the 3:30 panel that I'll be back for. Thank you.
Thanks, Lance. Amy, let's get started. One final reminder, please turn off your cell phones.
Good morning, everybody. Lance, I want to thank you again for setting the stage for our event this morning. I think you've laid out our issues in an engaging and very interesting way. So thank you very much. And I think that the rest of the day is going to flow forward much as has been described to us. I'm Amy Cohen. I am the Executive Director of the Center for Civic Engagement and Public Service here at George Washington University. Just momentarily, I want to thank Alan Morrison very much for working with my office and with the Career Center to get this program on the books. I think Alan had a great passion for this, and I think that we'll move it forward. The Center for Civic Engagement and Public Service has a deep interest in the issue of internships because a big piece of our work is getting students involved in experiential education in a variety of different kinds of ways, from the shortest term volunteer experience of 1 to 2 hours to really long-term, 1 semester, 1 year, and even longer experiences that may be paid, may be unpaid, may be credit-bearing, may not be credit-bearing. And so we are dealing with this whole gamut of activities, and we do it because we see this as a piece of experiential education and the best way to educate our students connected to their academic work. We also see internships as not only a piece of civic engagement for our students, but as perhaps invigorating to the workplace. When you bring in interns, when you bring in students from outside, you have an opportunity to change the way that you think about your workplace, whether it's public, private, or not-for-profit. These are the kinds of issues that we think about, and it's the reason that we're interested in doing this here today. But to introduce our panel. We have a fantastic panel this morning. Each of our panelists has been involved in supporting and overseeing internships in one way or another, and this panel is really designed to give you a sense of the landscape of internships. As I began to work on this, I wanted to put everything in a box. We do internships this way, and this way, and this way. But it's much more chaotic than that. I wanted to throw up Monets and Manets because I think the landscape of internships is ever shifting, and it doesn't lend itself to easily parceling out or even mapping. There are lots of variables, and nothing really captures that idiosyncrasy, but we're going to try to do that here today anyway. So our panelist is each going to look at internships from her perspective. We've organized this really to move from the broadest down to the narrowest. So in that fashion, we're going to start with Ann Scammon. Ann is the Director of Career Learning and Experience at GW's Career Center, and she's going to provide us with a broad definition of internships, and she's going to attempt a taxonomy of experiential education and experiential learning as they relate to internships. And you do have a great paper by Ann in your packet. We'll then move on to Allison Moriarty, who is the Director of Research Compliance at Brigham and Women's Hospital, and she deals with a very wide gamut of interns and internships at Brigham and Women's, which you'll hear about. After that, we will hear from Pam Gallimore. Pam is a human resources specialist at the Office of Personnel Management, part of our federal government and right down the block, and will talk with us about the issues that the federal government has mapped out. And finally, last but not least at all, is Jessica Tillipman, who is the Assistant Dean for for outside placement at GW's Law School. And they have a very defined and clear, I think, academic program, partly due to the ABA. So I think that will help us. So I'm going to turn first to Ann Scammon, who'll give us an overview of internships.
Good morning.
Good morning.
In terms of defining internships, Amy said that I was going to be able to do that. And actually, I'm going to turn to you to help me define internships. I have a couple definitions that I'm going to read to you in a minute. But let me just open it up to you and ask you, when you think of an internship, describe an internship, what word would you use? Anybody? Training? Mentoring? Expedience. Oh, experience. Okay. Expedience. Okay. Temporary. Yes. Volunteer. Networking. Unpaid. Very good. We're following exactly the way we're going. Yes. Others? Good. That's a start. Internships are many things. Internships are, as Amy said, largely, in terms of its broad spectrum, pretty chaotic right now. I think that it's important to note that it goes by many names: service learning, community service, volunteerism, practical training, experiential education, fieldwork, practicum, co-op, and internship. Many, many other names, titles, programs, activities that fall under this notion of experiential education that helps a student, helps a person to learn, and helps the employer in some fashion, but not very much. So, let me read a very formal definition for you. An academic internship, and let me say that this comes from a board member at the National Society of Experiential Education. And bear with me, an academic internship is a form of experiential education that integrates knowledge and theory learned in the classroom with practical application and skill development in a professional setting. Students earn academic credit, or there's some other connection to a degree-granting educational institution. This learning arrangement is overseen by a faculty or staff member and by a designated employee of an organization. The internship is over by now, by the way. The internship is usually the length of an academic term, may be part-time or full-time, paid or unpaid. The component of the experience that distinguishes it from other experience is the structured and deliberate reflection contained within learning agendas or objectives. So I think for many of us in the internship business, we would be pretty pleased with this. This is good? Okay. I doubt there are many interns or students in the audience who would say that this was their goal when they decided to apply for an internship. I think it might be a little bit more like this. I got this from Wikipedia. Intern is a temp position, much as Catherine was suggesting, with an emphasis on OJT, on-the-job training. Apprenticeship-like for college students, but also could be for high school students or postgraduate adults seeking new careers. Students gain experience, explore careers, create networks, and seek professional connections for their future. Plus, employers receive free labor for low-level tasks, an opportunity to try out potential hires who then may return after graduation with little need of training. Pretty different. You can see why we're here today. You can see why Alan and Lance consider these issues. So, are these both internships? They are. So, there's a wide spectrum, there's a lot to understand, there's a lot that's not understood, and I think that I'm just going to spend a little bit of time trying to look at this. Internships have varying characteristics. They're paid or unpaid. They can be for academic credit or not. They may be sanctioned by a university or not. They're perhaps between 4 weeks to 12 weeks. There are also externships, which are somewhat like internships, but they are for less time, which I won't go into. You may or may not have a supervisor. You may or may not have learning objectives. There are international internships. There are international volunteer experiences. There's a major initiative underway for international volunteerism and the importance of considering that. Internships, the students pay for the opportunity to do the work of the internship. One of my favorites. Washington programs, there are Washington programs where students come, live in the Washington area, attend classes, and via third-party arrangements stay here in the metropolitan area to receive credit. So there are a variety of ways that internships can be described. I think many of us have the notion of these various characteristics. But historically, internships are really linked back to apprenticeships and to cooperative education. In 1909, Northeastern University had the first cooperative education, or one of the first, University of Cincinnati as well. These were paid internship-like experience where a student stayed was in college and worked for an extended period of time and always was paid. And it was linked to the academics. But in the 60s, these notion of unpaid experiences, similar to co-op, but termed internships, emerged. So let's talk a little bit about internships today. It's many formed. They're a common part of young people's experience in college. It supports their career development. It supports and assists with their future job search and professional advancement. 78% of GW's 2009 undergraduates participated in an internship or volunteer experience. 78%, close to 4/5 of our student population, undergraduate population. 66% participated in some sort of part-time or full-time job, and 22% participated in cooperative education. Time magazine stated in July of 2009 that 300,000 students participate in some form of pre-job internship apprenticeship in the U.S. 300,000. And there are many of our current cultural heroes, are the people that young people and adults look towards, were interns. Bill Gates was once a congressional page. Oprah Winfrey interned at CBS. And NBC News' Brian Williams was a White House intern for the Jimmy Carter administration. Further, and these are interesting statistics, the National Association of College Employers surveyed their employer members, primarily corporations, nonprofits, and federal government agencies, about the importance of internships and recruiting in the current economic, in the market, in the economic situation. 83% of these employers stated that their internship programs were designed to recruit entry-level college hires. 83%, it was designed, these are the individuals said. 45% of their 2009 entry-level hires came from their own internship program. Nearly half came from their internship program. Internships are very important. I mean, look at this in terms of the direction of if you're a parent, if you're a student, in the direction of a young person's life, this internship is very important. And they also stated that 98% of their internships were paid. Now again, these are large corporations, major organizations. So most internship programs are created in a college setting through by a university determining they want to expand their internship program. It's based on institutional mission, their policies, faculty, curriculum, and the interests of the students. And this is really how they're started. Some universities mandate that all students participate in an internship experience, experiential education opportunity. Places like Drexel and Northeastern, the University of Cincinnati, and other universities, it's fundamentally a part of their their educational philosophy, the foundation of their educational philosophy. And it's worked into the curriculum in every perspective. Other organizations, other institutions like the University of Maryland have something called the President's Promise, where students are guaranteed that if they want to participate in some kind of experiential education opportunity, study abroad, internships, co-ops, service learning, that they'll have that opportunity. And others are much like GW, where there are a combination of programs, where there's service, where there's an interest in internships, as you said, I saw from the statistics. Basically at GW, we have non-credit, unpaid, or paid internships. We have academic internships, cooperative education, community service, volunteer, service learning, and federal work study. These are the 6 areas we see primarily on our campus and many other institutions around the country as if they don't have a university-wide mandate, this is the way they approach it. The independent non-credit, the major issue I think that we find with this is students go into the workplace, they look for an internship, they go to the internship, they're unpaid, there's no educational experience necessarily attached to it in a structured fashion. They pursue their interests without the responsibility of academic credit, which in some cases is just fine. The issue is it's not managed, it's not tracked or monitored by the university, and any coaching that might be offered for a student by a staff member or someone in the university setting in terms of accessing protections that might exist but probably don't are not there. School-based are credit internships. This is usually out of the dean's office or the department of the dean's office in the university setting, and primarily those are related to an academic course that a student is able to pursue and receive academic credit for with a faculty advisor and with the signing off the agreement of an employer who agrees to oversee and manage the internship experience. These are quite popular and used regularly. Some students don't want to go through the paperwork and the hassle. They perceive it as a paperwork and a hassle. I'm not saying, of course, that it's a paperwork and a hassle. Cooperative education also exists at GW. This is always paid. Often it's for credit. At American University, I know it is always for credit and not necessarily always paid. So co-op too, within the co-op, it can change and is slightly different. There's a transcript notation there, regardless. And then we have the Federal Work Study Program, which many people are familiar with. These are considered at GW the first career step. There are many, many service opportunities. We have an active Office of Community Service here at GW where students last year were able to participate in over 163,000 hours of community service activities. And that students can use this as a part of their educational experience. They can link it to their academics in a structured fashion. And of course then, and finally, is service learning. Service learning, we have over 43 service learning courses here within the institution. And these are opportunities that to bring together the community, the ability for students to learn and have reflection, and to serve the community as well. So these are a variety of the different areas that are available in terms of GW, but also in terms of how many institutions in the university approach in the country approach internships and approach volunteerism and approach part-time jobs. In this situation, I think the focus on unpaid internships is important because many times that's what it does come to, is an unpaid internship, and whether or not there's learning is often to be determined. So with that, I'll pause and just say again that this is an experience for students across the country, and we continue to pursue it today. I think we'll have an opportunity to see how just we can make it the best for students for their own education and for their futures.
Thanks, Ann. That's great. And I think we'll move straight down to Allison. At the end, we'll have opportunities for questions and comments from the audience. So, Allison.
Hi, everybody. So I'm Allison Moriarty. I'm the Director of Research Compliance at Brigham Women's Hospital in Boston. We are, most of you may be aware, but we're a large teaching hospital in Boston. So I spend most of my time worrying about terms and conditions of NIH awards and human subjects and animal subjects welfare. But about a year ago, my office started getting a lot of questions from investigators across our community about research volunteers. And the question at that time was really whether and how these volunteers should be onboarded within our system, and also whether the investigators could be issuing sort of small token payments to the volunteers to recognize the good work that they're doing. So about a year ago, I started, I initially did not have any sense at all for what this would turn into, but started sort of looking into, okay, how shall we be thinking about these research volunteers? And as I started digging into some of the language around volunteers, Fair Labor Standards Act, started to really appreciate some of the complexities across our system and how this sort of works operationally. What we ended up determining very early on was that for all intents and purposes, on the research side of the house, I'm not going to really talk about what's happening on the clinical side of the house at the Brigham. We don't have a whole lot of volunteers, or we have trainees, certainly, as Lance Liebman spoke to. But hopefully it wasn't our hospital, but it may have been back in 2001. We've come a long way, if in fact it was us. Since then, I think we pretty uniformly on the clinical side of the house do treat all of our trainees as employees now. But we have a little bit of a lag on the research side of the house. At any rate, when we started evaluating about a year ago, we made the quick determination that for all intents and purposes, we don't have volunteers, or we should not have volunteers on the research side of the house, because we don't really meet the goal of sort of charitable or humanitarian work. Most of the people working in our research labs are involved in pretty substantive sort of laboratory work. And so we started to try and understand what it was that people were actually doing, and thinking about sort of roles in a more substantive way, as opposed to simply sort of labeling people easily. And what we found as we started sort of turning over that rock and evaluating who is actually within our system, we have a huge spectrum. So, Anne just spoke to sort of all the various types, and I would say at the Brigham, we have almost everybody in various capacities across our research community. So our research community is large and very decentralized, working in sort of independent labs across Boston and Cambridge. We are closely affiliated with Harvard. In fact, most of our faculty have Harvard faculty appointments as well. We also have affiliations with a number of the institutions, academic institutions across Boston. So we are a very sort of large, diverse population. We have people ranging from high school students to postdocs who are coming to us looking for experiences in our lab. I would say as we have evaluated this, we have ended up focusing most of our efforts on understanding the postdoc side of this, because that's where we see the sort of greatest need from the postdoc community looking for those types of experiences. And we obviously don't have the capacity to support the number of people who want to come to us and experience what it is to work in a biomedical laboratory. But just sort of quickly in context, in thinking about all the different types of people, so we have people coming to us in high school. So we have some formal programs at the Brigham, a program called Science Works, which is specifically designed to give mostly city kids, high schoolers, opportunities to work in labs. In those, some of those programs are paid programs, some are unpaid programs, but the goal across the board is to help people get exposure to the research world, to think about sort of whether they want to pursue a career in biomedical research. We have a number of people who come to us as undergraduates. We have some formal collaborations. For example, with MIT, we have a very interesting and prolific group that works in bioengineering, and they work closely with MIT. And we oftentimes have MIT undergrads coming for the entire 4 years that they're in school working in that lab. The question is, of course, sort of what type of work it is that they're doing there. Some of these people are getting credit for the work that they're doing in our lab, some of them are not. All of them ostensibly are supporting their degree in science, but of course the question is sort of how formalized is that, and how much do we understand what it is that they're getting out of that relationship. We have exchange programs with international organizations. So for undergrads, for example, we have undergrads that come to us from India for 6 months, and they'll come and work for us. We do not pay them for the time that they come to us. Ostensibly, their home institution is, they're working under a formal curriculum there, but having the experience within our labs at the Brigham. We have a number of grad students who come to us, both at the master's level and at the pre-doctoral level. Most of them are working in our labs on their dissertation or thesis work. So oftentimes the work that they're doing directly associated with the sort of productive work that's going on in the lab, but it is for the goal of their own independent dissertation work. And then we have the postdocs. So these are people who have mostly recently graduated from their advanced degree programs, both domestically and internationally. But I would say that the vast majority of the people that we see in the context of a sort of internship or training experience mostly come from foreign programs. The situation is basically across the board, whether domestic or internationally. In the research world, didn't so much used to be the case, but certainly is now, that much like on the clinical side of the house, you now have to complete a postdoctoral research fellowship in order to even qualify for an academic track appointment. And typically, that's a 3 to 5 year sort of research fellowship. It's considered a training experience. Most of these people are paid, like on the clinical side of the house, if they are paid at all, they're paid typically fairly low level in recognition of the fact that they are in training. But we also have people, so we have a lot of research fellows who are being paid a low amount, but nonetheless paid for their experience as a fellow. But we also have a number of people who come from foreign programs mostly, not across the board, who have an MD or a PhD, but really don't have comparable experience as people who are graduating from domestic programs. And they're coming to us, they don't yet have the skills to be competitive for one of these research fellowships. And so obviously we can't be offering them paid opportunities, but they are desperate for the opportunity to work in a Harvard-affiliated lab. And it's very hard for us to turn them away because the benefit to them is enormous. Although obviously, we struggle with how to create a training experience for people in our labs that meets the test of sort of all for the benefit of the trainee, not for the benefit of the institution. Because what these people, as soon as you start working in a lab, there is substance. The only way you learn is by engaging in substantive substantive work. So we've struggled quite a bit with how to draw that line between these sort of trainee postdocs as opposed to the paid postdocs who are working in similar types of projects. We also have people, for example, many of our paid research fellows come on J visas, and they'll have spouses, trailing spouses who come with them and who are on J2s or other types of visas that have limitations that basically say they're not allowed to formally work in the country. And so the question is, are they sitting on their hands for the, sort of for the whole year that they're here? Many of them come to us and say, we want to do something. We can't be employed, but we'd very much like the opportunity to sort of be in a lab, to experience a Harvard lab. And the question is, do we turn them away, or do we offer them opportunities? So, quickly, sort of in summary, as we've looked at this entire sort of continuum of people who very much want the opportunity to work in a busy lab, we've ended up taking the stance that we have either paid or unpaid trainees. Clearly, this entire continuum, they're all trainees in various capacities. People, if they are paid, have to meet our Brigham wage standards. So we ask that anybody coming in of any sort of paid capacity, if we are issuing any type of payment to them, then they need to have a job description. We need to categorize them as we would any other employee. The alternative would be that they are unpaid. There's no sort of gray area in between. If people are coming in an unpaid capacity for any reason, whether they're enrolled in a program or not enrolled in a program, we now have put together a relatively structured research training program across the institution. So every department is now being asked to create a formal research training program curriculum. And every person who's coming in any type of unpaid capacity now has to have an individual training plan that essentially creates a whole training curriculum with training goals, with how they're being supervised, who's providing the supervision, what the training experience will be. No one's allowed in our doors at this point without some sort of formal documentation that clarifies this training role. It's not been well received by the research community, but nonetheless, we feel as though there's no we have to have that level of structure in order to be comfortable with the requirements.
That's great. And Pam, I think this leads very nicely into the structure of the federal government.
Yes, I'm from the Office of Personnel Management, and I'm going to be kind of more of the overarching federal laws and requirements in relation to student volunteers. Shockingly, we are governed by, the federal service is governed by specific laws and regs governing who can be paid and who can be considered quote-unquote a volunteer. Appropriations law under Title 31 prohibits the federal government from accepting volunteer service. However, as with most laws, there is an exception. In Title V, United States Code, Section 3111, there is a specific exception for the allowance of volunteer services for agencies to accept volunteer services from students. We also have a regulation in the Code of Federal Regulations that, for all intents and purposes, repeats the law because the law is quite specific. For an agency to accept a volunteer as a student, number one, they have to be enrolled for not less than 1/2 time. You have to love the way laws are written, as opposed to saying part-time or more, not less than 1/2 time. The educational institution must okay the assignment. The student must be on an established agency program to provide educational experiences for the student. So again, the goal is to provide the educational experience for the student, and the side plus is that the agency also gets some assistance, and probably very needed assistance. For a student volunteer, you must be uncompensated. That is in the law. And for all intents and purposes of other federal laws, a student volunteer is not a federal employee. The only time, and it is specifically identified in the law, that a student volunteer could be considered a federal employee only for instance, on-the-job injury under a specific title, a specific chapter of Title V, and tort claims. IRS, if anyone is interested in going to volunteer for the Internal Revenue Service, there is a specific separate set of laws that a student volunteer would have to adhere to under the Treasury laws. Meaning, gee, I guess it would be not giving out famous people's tax information. As a student volunteer, there are no benefits accrued. Basically, the service is not creditable for any other federal benefit. There's no leave earned because you're not being compensated. You're not considered a federal employee, okay? There is no health, life insurance, or retirement because you are not a federal employee. The only reason you are a federal employee is if you get hurt, so on the job, so that you could be compensated under Chapter 81 of Title V. Now, we have the specific government-wide exception for student volunteers in Title V, Section 3111. However, each agency within their Appropriations Act or Authorization Act may have a specific exception from the overarching prohibition on volunteer service in the federal government. And that generally, for example, the National Park Service can accept volunteers from other persons of students, other than students, for service in the parks during the summer. But they have to have a specific legislative authorization to do that in order to go be a volunteer for the federal government. In relation to under student type appointments. As was alluded to earlier, we have the Student Temporary Experience Program, which is called the STEP. We do love our acronyms. And the SCEP, which is a Student Career Experience Program. Now, the Student Career Experience Program has to be academically related to the employee's pursuits, and this is an actual appointment in the federal service. Okay, both the STEP and the SCEP are appointments. Again, the only volunteer service that is allowed is under that specific section of Title V for students. Generally, a SCEP would allow, it must be paid because you're a federal employee, okay? As opposed to other sections, federal employment, shockingly, is also defined in law. And Title V, United States Code, Section 2105, specifically says what you have to be, or what you have to be doing. You have to have been appointed by a federal official, performing federal work, under federal supervision, is technically the definition. And even though it is so defined, there are a lot of case laws, and our overarching judicial body is called the Merit Systems Protection Board. And the Merit Systems Protection Board issues or adjudicates claim of federal employees on a violation of law, rule, or reg in the federal service. The board has issued precedent decisions on what Section 2105 may mean. So if you're interested in pursuing that course of study, please just research the board's decisions for definition of employee or Section 2105 of Title V. Under the SCEP, which is the Career Experience Program, again, it must be the work experience and the agency must be related to the student's academic pursuits. That must be in coordination, the student, the academic institution, and the agency must come to agreement on the parameters of the appointment. The student is entitled to benefits, including that's a new one, health, life, and retirement. Okay. We're going to change that in the next proposed regulation. No, and the employee earns sick and annual leave. And under the SCEP, and only under the SCEP, the employee, the student, may be converted to a permanent federal job upon graduation, recommendation by the academic institution, and performing at least 640 hours of service within the agency. These are regulatory requirements that must be met, but it is a step into the federal service that would require no further competition. Okay. There is no central repository for these type of positions or opportunities. Anybody who's interested in either a student volunteer type experience or for a federal experience under the student experience programs, then you would want to go to each web page of the agencies whose mission interests you. Generally, each agency on their web page is going to have a specific section on either employment, and most of the larger agencies will have a subsection on student employment. It will provide information on their internships. Agencies establish their own within the parameters of our laws and regulations. So the agency would provide information on the types of opportunities they would have, be it volunteer or an actual federal appointment. Would it be under STEP, which technically under the temporary appointment authority for students is for basically not to exceed 1-year increments. As long as the person met the definition of student, that appointment could be extended. And for the purposes of a STEP, it does not have to be academically related. It's basically an opportunity to earn salary during the period of the person's educational pursuits. And then there is no conversion privilege. Once the person graduates from whatever program they're under, they are no longer meet the definition of student and lose their job as a temporary student employee. Also, we have a studentjobs.gov website, again, shockingly. It's on basically the usajobs.gov website. That's the OPM, Office of Personnel Management website, where every agency must advertise most of its positions. I say most, and we're not going to get into the semantics of federal service because that would just totally ruin the rest of the day. In relation to competitive service jobs, most executive branch agencies are in the competitive service, and agencies must advertise their competitive service jobs on USA Jobs. Within USA Jobs, there is a studentjobs.gov, and that lists not only an opportunity for agencies to list their student jobs, which of course are not in the competitive service, so agencies are not required to list them, but they, in order to seek and explain to the students out there what opportunities they have, most agencies will at least list their programs on studentjobs.gov. And within that particular website, there is an additional site or subset or link to additional opportunities that are available for students, which could include the unpaid volunteer, unpaid internships, unpaid fellowships. They're called a variety of names because they're agency specific, and the agency establishes each one under its authorities that they may specifically be granted by law or under the overarching federal authorities that they are allowed, okay? And in relation to the FLSA topic, OPM regulates the Federal Labor Standards Act in relation to federal service. Department of Labor does the private sector and other than the federal service. Our regulations are in the Code of Federal Regulations, Part 551, and generally the law says that the federal regulations must be consistent with labor's, but to the extent practicable, but it doesn't necessarily have to mirror. And our regulations pretty much explain and provide examples of what is a professional employee under the law and under OPM's regs, what is a trainee. Volunteers are specifically exempt from our chapter. And the agencies administer, and if somebody believes there may be a violation of the FLSA in the federal service, they can file a claim with the Office of Personnel Management. So it's slightly different or dramatically different, however your view is, in relation to the federal side and how we apply the FLSA in relation to volunteers or student trainees and in relation to the private sector. Okay?
Great. Thank you very much.
Pam, I had to smile a little bit when you actually started talking about the laws because I sign hundreds of your forms every year from our students from the different federal agencies that we have working for them. So I'm very aware of what they say. And they do vary by agency, actually. So I guess the program that I head up at GW, I'm the Assistant Dean for Outside Placement, kind of a confusing name because it's not actually a placement office, but it requires students to come to us once they already have an externship. It's quite narrow compared to everything else you've heard up here today. While the school students may do other things within the school, like pro bono, or may have paid jobs, or maybe just decide not to get credit, the program that I run is actually very simple, very straightforward and narrow because it is governed by the American Bar Association guidelines, or the ABA. And it's what I would say at GW, it's pretty much easily said the most popular class at the law school for students to take. And many students actually say that, along with maybe some clinical experience, it's probably their favorite experience while at law school, because if you're coming to law school in Washington, D.C., you're coming here to spend time doing externships working for the White House, or working for Congress, working for the Department of Justice, the ACLU, working for some of our federal courts or even local courts. So, there's infinite opportunities for GW law students. The way that the law school's program works here at GW is based partially on not partially, totally under ABA guidelines, and then the law school faculty's interpretation of those ABA guidelines. Again, like I said, they're quite strict. The whole purpose of them, I think the ABA would say there's more purpose, but my theory is they don't want law schools simply just taking money from students to give them credit for getting nothing else in return. Simply, you don't just go do some work, we'll take your money, we'll give you credit. What they're saying to schools is you need to follow a much more structured program in order to ensure the students have a reflective learning experience, that they're getting something more out of this than simply something showing up on their transcript. So the basis of these guidelines, I'd say they're quite broad and vague. They have some interpretations that are somewhat useful, but most of the time, a bunch of the people in my role at my counterparts in other law schools scratch our heads trying to interpret some of them. But some of them are pretty clear. Unpaid. You can't be paid for this type of job. You also have to be under the supervision of a faculty member. It can be part or full-time. You also need to have a strict program in place. You need to have grading guidelines and be very clear about what your expectations are. You need to be, have some sort of training methodology for your supervisors. All of you, basically, I could go through the list, but the gist of it is there's quality control. They want to ensure that there's a certain level of expectation that's being met with these externships, and that on the law school end, there's a certain level of supervision. Our faculty has interpreted that by imposing additional guidelines on the students that they're not always well received, but they're there to, again, ensure quality control. We require students to work a certain number of hours per week if they want to receive credit, or per semester. We require them to fulfill certain work product requirements, meaning we want to ensure that when they have their externship experience, that it is a good externship experience, that they're not just going to work and do filing, they're going to get actual legislative or legal work experience. So part of these factors or requirements that we place on these students are for them. They don't see it that way sometimes, but they really are for their protection, to ensure that if they're not getting the type of work, they can go turn to a supervisor and say, hey, look, it's the school, they're making me do this, and it makes the situation a little less awkward. So we have those types of requirements. On top of that, and the biggest requirement is the mandatory co-requisite course. The ABA doesn't require that, but what they do say is that you have to have some sort of structured reflective component along with the actual externship in order to award credit. Our schools interpreted that as a co-requisite course. So for example, if you're working at in the judicial chambers of a judge at the DC District Court, you would take a course called Craft of Judging, taught by our local judges in the DC area. We offer government lawyering to those students working at the Department of Justice, at the EEOC, Department of Labor, or any other government agency. And then we also offer a public interest lawyering course for students that are working at public interest organizations. On top of that, we have some more flexible courses where, let's say, for example, someone's working at the Patent and Trademark Office, they could take a patent law course, the traditional patent law course, and perhaps do a one-credit supervisory project with the professor of that course, so that they're integrating their experience at the patent office with what they're doing in the classroom component. So all of this, again, is quality control. The GW program is extremely large, like I said, very popular. We average anywhere from 150 to almost 250, depending on what time of year. Summer's obviously our busiest time of year. It's not permitted until after their 1 year, so we really have 2Ls and 3Ls. We also allow LLMs, or students getting their legal masters, to be part of the program, although they're not quite subject to the ABA regulations, so it's not as stringent. So as I'm describing it, it is quite different from what you've heard up here, because it's not a giant amorphous program. It's very limited. It's very strict. It's a strict credit bearing. It's got course numbers. It's limited in its scope. Again, not all GW students with externships will go through it. You don't have to do this program. If you want to get an externship, a lot of places do require it because of the FLSA. I should probably get that right here. Because of that, they have concerns, so many students do run through our program. But at the end of the day, that's basically what we're about. And I know you want to leave time for questions.
Great. Thank you very much. When I first heard about this program from Jessica, I realized that what she was describing in my parlance was a service learning program. She's got students who are working out in the community, but really reflecting on it and working through it in their coursework. Yet it's called an internship program. And so I think for me, it exemplifies some of the questions that we have here. We have, I can ask some questions, but I think I'd like to hear from the audience. We've only got about 10 minutes for some questions, maybe even a little less. So if you'd like to ask a question, please come to one of the mics and address that to our panelists. Otherwise, you can hear from me. Come on up.
I can speak pretty loud. Can you hear me okay?
Yes.
Okay. So I work at the University of Connecticut, and I do a lot with the students with unpaid internships, and my big concern is their liability. That when they go out to an unpaid internship, whether it's for credit or not, our university does not cover them, with the exception of nurses, medical, Can any of you address that topic? Because that's something that I have to work on, is to find a blanket insurance policy so the student does an unpaid internship. They're not left high and dry, because I really think they are if they're not paid.
We all turn to.
We're all looking.
From the federal perspective, they're covered by the Department of Labor's Office of Workmen's Compensation Programs. So they would be covered by the on-the-job injury under Title V for a federal volunteer.
What about harassment type situations? So they're not sued, or if they're the victim of harassment, or that kind of liability as well?
That I can't get into from the federal side.
Do the students have to register with your career center or your internship?
No, only if they're doing it for credit, and then it's by department.
And do you have any type of sort of formal agreement with the people with whom you're placing the students, or that's sort of part of the issue, is that you don't have formal? They place themselves.
We have affiliation agreements, doesn't mean they're always signed. Again, they don't always have to tell us. A student can find an unpaid opportunity
Right.
and not notify the university at all, and again, they're left high and dry if they're the victim of a situation, or potentially if they get hurt, if their medical insurance doesn't cover it. So I just didn't know if any of you knew of any blanket coverages type information.
What does your general counsel say?
Keep looking.
How helpful.
I found some in Colorado, the state of Colorado does something, and I'm starting to research. And they're gonna support me, but I have to find it.
I mean, I can certainly say at the Brigham, we've tried to evaluate sort of all the issues of liability for all these different types of people. We have, as part of this sort of new structure that we've put in place, we have a trainee letter, a sort of standardized trainee letter in which we say that we are not liable. That being said, I don't know that our institutional position, I mean, so we have that documentation in place. We feel that that's important. In reality, I'd say it's not as clear, the lines of liability, and so we would evaluate situations probably on a case-by-case type of situation. But I would say institutionally, we'd probably be very uncomfortable signing some sort of formal agreement for, by which we accept liability for what unpaid trainees are doing.
I've never seen an agreement like that,
No, I
nor would we probably sign one, so.
From a risk management perspective, you may want to put something on the internship listing that alerts students to the concerns or that they may have, and we've done that at the University Career Center. And I think that's important. It certainly doesn't. It's certainly not a liability. It's certainly not an insurance that it won't happen.
Question?
Yes.
Good.
Hi, I'm Catherine Stahl, and I'm Executive Director at the Career Center at American, and here in town. And our recent graduating class was more than 85% of our undergraduates did internships by the time they graduated. We are founded as an experiential education institution, and we, like GW, we're here, like Georgetown, et cetera, and our students come to do internships. It's a major motivator. The problem we have with unpaid internships is multifold. We do have this legal situation where students sign a release, and we don't consider that a wholly cover, it doesn't cover us completely. So we have the issue of just taking care of all of those students who are registered, which is about 1,200 a year for academic credit. But if they're in an internship and we know about it and they come to us, our Career Center is the hub for every single student on campus, undergrad and grad, can do an internship. So we take care of, we deal with it, whether it's sexual harassment or whatever, we feel our obligation ranges. The bigger issue that's been happening to us recently is simply about unpaid. Among these 85% plus students and about 70% of our grad students that do these internships, those that are at the undergraduate level that are in unpaid internships that are told that by the employer that they must register for credit. And in fact, my favorite is when employers say, we offer university credit for this internship.
Right.
It's like, what university are you? Come on. We offer university credit if we say that it's creditworthy. So the issue is, and I believe I've been at the university for 20 years, and there was a case with WETA where they actually put it out in Variety magazine and said, if the student comes and works with you and they are not doing something that is really trainee, you have to pay them. Like if they're at the front desk, you have to pay them. And if they're in a trainee position, they must be earning credit. This concept, which is not in the law, in the Fair Labor Standard, that you must be earning credit, is just an insurance policy for employers. What they don't understand is you're not paying them and you're asking them to pay $4,000 in credit to come for the virtue of not paying them. And it's all about you and not about them, because you show me an employer in Washington, D.C. that didn't get anything out of their intern that benefited their employment. which I think is different than research where you're in an active learning. You may be able to contractually come up with an active learning, but unless you're a boom operator or an editor that never is allowed to show your edits publicly and all you're doing is learning how to edit behind the scenes, it's really hard to prove that you haven't given some benefit to the employer. So our concern, and you meant somewhere in your paper, Anne, you mentioned zero credit. And we instituted a zero credit last year, which is called a transcript notation. I believe that most of our employers do not know that it's zero credit. We don't call it zero credit, we call it a transcript notation. Are you engaged? Are you registered? And the student says yes. If the student's asked, are you registered for credit, they have to say no. And if they say no, most of these employers will kick them out. And we found, we anticipated 20 students needing this a year because they were forced to register for credit, and last year we had 200. So we are having to change our entire credit based so that you can register for a quarter credit. So, because our students are going to community colleges and trying to register for $100. They're trying to find some way to get around this, because we offer credit to any student who has the potential to put it into their program. But we've interviewed these students. Why didn't you register for credit? Sometimes it's, I didn't know that I could, but usually it's, I don't have enough room in my program, I don't have enough money. There's, whatever the reason is, I see this as a really exploitative situation that we should not be engaged in, even though I think that unpaid internships in certain sectors serve a real purpose for students. So my staff says to me, don't talk against all unpaid internships because of the value it can give students. But if we're not tracking them, if there's students going out and getting their own internships, and yet they come to us, especially in the summer, saying, I have to now pay for this credit, and I have no room nor money. How am I going to live in New York or live in Washington on an unpaid internship? And pay for credit, go into debt for credit in order to work for free. So that particular conundrum for me, I think could be, I think that the Labor Department could be more direct they don't say that you must register for credit, but the FLSA says, like registering for academic, like receiving academic credit. And I'd love to see that interpretation much more clearly outlined, that registering for credit is not the only way to show that you have something like a substantive contract that shows the learning that's going to take place, is a far less expensive option and can be administered by people that are not faculty who are in a credit registration. So that's my biggest concern for our students, and it's growing by leaps and bounds, and I think this bubble's going to really burst in the face of many. And we have had a case many years ago where a parent, when they got sued because the student had been paid a stipend, and they realized, and then was owing taxes, and they realized that they should be actually paid minimum wage, and the taxes should have been taken out, and they were really working alongside others who were getting the same thing. So that has become clearer and clearer, but this unpaid is a morass.
One thing at some universities, and at GW we do this, is that for undergraduates, you pay a certain amount for your 15 credit hours that allows you up to 17 hours of credit. So students register for 2 credit hours for an academic experience, but they're not paying anymore, though they're getting actual credit. And
if that works, they can do that. Yeah, some of our students
that's very helpful. That helps.
We have that too.
So I think that's important. I think.
But we still had 200 of them that couldn't come in. Either they were taking so many credits. I mean, they're all doers. They're taking so many credits they used up the 17.
Sure.
Or they literally didn't have anything they could register for. For those students, those of us who work with students in the School of Communication, when the accreditation of schools of communication say that you can't have more than 1 course worth of internship. And so those students are not allowed to do more than one if it's a full course. So there are all kinds of restrictions that are part of the academic community. I think that's a nice one, but somehow these 200 kids slip by, and again, I think there's a bit of a shell game going on here. Not that our lawyers would like to hear me say that publicly, but you know, what is a transcript notation?
I think in some ways, we have to be careful what we wish for, because on the one hand, what you're describing is this incredible degree of flexibility that we have afforded to students, to employers, and to ourselves around how this can get done. And so we've got this incredible flexibility. Nobody wants to say no to a student. No student wants to say no to a career opportunity or a career/academic opportunity as an internship. And yet we find ourselves in this place where students may have issues of liability, and they may have to pay to do an unpaid internship and along the other standards. On the other hand, if we ask the Fair Labor Standard, if we ask the Labor Department to come in and give us clear guidelines, we may not like what comes back to us. And my concern, as we open this can of worms, my concern is, do we, as your staff would say to you, do we do away with all unpaid internships? What will that mean for students? Because we're going to hear from employers momentarily, and they'll tell us what value this is to them, but my guess is it's not, all interns are not equal the minimum wage. And
Well,
so,
I also think that, I'm not advocating to eliminate unpaid internships because I think there is a huge value added. What I'm concerned about is when the interpretation is on the part of HR lawyers, is a lockstep, you show me you're registered for credit,
Right.
we'll let you work for free for us, which I don't think is embodied in the law. And yet that's the easiest way for a lawyer in an HR office to say, this is what we're going to take.
And I have to say, I mean, just from Brigham, I'm very uncomfortable from an employer perspective with that approach as well, because the relationship between the sort of liability is at the employer as far as what that relationship is and whether there's a wage for the work that's happening at the employer. I don't have any comfort at all that whatever they're doing at their home institution meets whatever our internal standards might be, which is why we've taken the position that we're essentially blind to academic credit, because it's not relevant to what it is that we're doing sort of actually in our labs.
It's a wonderful thing that you've done. You've created yourself as an educational institution because of the demand, which I think is fantastic. Well, we're going to wrap this up here. I think this has been a fantastic panel. We've laid out some of these issues. We've got a brief coffee break, so